There is a procedural doctrine called the Judicial Conduct and Disability Act. No public body enforces it, and it has existed since 1980 as the only mechanism for holding a federal judge accountable. It was written by judges. It is administered by judges, and it explicitly exempts the 9 most powerful judges in the country from its reach entirely. When an ordinary person files a complaint against a federal judge for bias, for an undisclosed financial conflict, for conduct that would end a career in any other profession, that complaint does not go to Congress. It does not go to the Department of Justice. It goes to the chief judge of that judge's own circuit, a colleague, someone who shares a building and a professional interest in protecting the institution they both serve. The chief judge reviews it alone. The chief judge can dismiss it alone. If you appeal, it goes to a judicial council, which is also judges. There is no external body anywhere in this chain. This system was not written into the Constitution. It did not emerge from a foundational design. In the 1970s, Congress grew uncomfortable with the fact that no formal complaint process existed at all, that grievances against federal judges simply disappeared. So in 1980, Congress passed the Judicial Conduct and Disability Act. But here is what almost no one noticed. The courts helped write it. The Judicial Conference, the administrative body of the federal judiciary, drafted significant portions of the implementing rules. The people the law was meant to govern participated in writing the rules that governed them. The statute created the appearance of accountability. It did not create the mechanism. And the moment it passed, the federal judiciary became the only branch of American government with a formal ethics system that answers exclusively to itself. Today, the Judicial Conference administers the act. It is composed of the Chief Justice and the Chief Judges of each circuit. They set the rules. They review the complaints. They publish an annual report that tracks how many were filed, how many dismissed, how many resulted in formal investigation. And when a matter is serious enough to be referred upward, the conference has the authority to certify it to the House of Representatives for potential impeachment. In the entire history of this act, across more than 40 years, that certification has happened exactly once. The judge resigned before the House acted. One referral, 44 years. Draw your own conclusions. Here is what this means for a person standing in front of a federal judge. If that judge owns stock in a company whose case is before her, and she does not disclose it, you can file a complaint under 28 U.S.C. Section 455, the Federal Recusal Statute. It goes to her chief judge. That chief judge can dismiss it as frivolous or directly contradicted by the record. The language is in the statute. The dismissal does not require a public explanation. It does not require notifying you of the reasoning. Between 2008 and 2013, the only window for which detailed data was systematically published, chief judges dismissed over 3,800 complaints against federal judges. They referred 0 for formal investigation. 0. In 2021, the Wall Street Journal reported that 131 federal judges had presided over cases involving companies in which they or their families held stock, in direct violation of the federal law requiring recusal. Violations of that law are self-reported. They are reviewed by the same body that wrote the implementing rules. Some of those judges said they simply didn't know. There is no mechanism to verify that claim. And no one outside the judiciary is empowered to try. Remember, no one voted for the structure that makes this permanent. Congress can amend the act, but here is the lock. Any statute creating external oversight of the judiciary can be challenged in federal court, and federal courts decide whether that oversight is constitutional. The courts are the final arbiters of how much accountability they can be required to accept. The same constitutional doctrine that protects judges from political pressure, Article III lifetime tenure, salary protection, removal only by impeachment, is the mechanism that shields judicial misconduct from everyone outside the building. It was designed to protect independence. It also protects concealment. And here is the part that should actually worry you: it's completely legal. Every piece of this is operating exactly as written. The complaint forms exist. The councils meet. Reports get published. Nothing is technically hidden. What is invisible is not the law, it's the outcome. The pattern of dismissals, the non-referrals, the retirements that close a case before a finding. Every other institution that holds power over your life, a hospital, a bank, a police department, has some external body with real authority to intervene. The federal judiciary does not. It built the system that exempts it, and the legislature that was supposed to be its check signed the bill. So ask yourself this: if the body that interprets the Constitution also decides how accountable that body must be, who, exactly, is doing the governing? And if the answer is no one outside the system itself, what does that tell you about every other institution you've trusted to watch itself?